Hello everybody, this is attorney Jesus Martinez, and today I want to talk to you about extreme hardship for waivers. Extreme hardship applies to different types of waivers. In this video, I want to talk more specifically about the 601A waivers, which is needed when someone has unlawful presence in the U.S. The I-601A waiver is only for unlawful presence. If someone has any other ground of inadmissibility, then they would perhaps need other waivers. For the ground of inadmissibility of unlawful presence, the 601A waiver or the 601 waiver is what is needed. In order to qualify for a 601A waiver, you need to establish that you have a qualifying relative, that you have a U.S. citizen or legal permanent resident, spouse, or parent. For the 601A waivers, children are not qualifying relatives. Once you have that qualifying relative, what you need to show is either one of two things. One, that if you were to go back to your home country, that your qualifying relative would suffer extreme hardship being separated from you. The second way you could show extreme hardship is by showing that if your qualifying relative were to accompany you, were to go with you to your home country, that they would suffer extreme hardship in that scenario. Now, what is exactly extreme hardship? The law doesn't specify one particular thing. It doesn't say if you have this, then you satisfy, you've proven extreme hardship. What it shows is various different factors. Depending upon your case, you may have some factors, you may not have others. That does not completely bar you. What the law does say is that it's a case-by-case analysis. Basically, they weigh the factors, they look at cumulatively all the negative factors in the case, and after seeing that, make their determination. Some of the factors include medical health factors, education, community ties, job prospects, the language that is spoken in the home country, and then the language that the significant other speaks. And what you have to keep in mind is just, does this create difficulty? For instance, if your significant other has high blood pressure, if they were to relocate to your country of origin, would that pose a hardship to their condition? If there are doctors that can give them prescription for high blood pressure, then that factor may not be that strong, because if you're saying my significant other has high blood pressure, this would create a hardship. But if they can get that medication that they need for that, then it may not be that strong. However, if you were to create some other arguments, or if you were to show that although they can get medication, there are other dangers there that would cause their blood pressure to rise, they're scared of the dangers there. They're scared that I have a cousin who was threatened, I have a brother that was threatened that they would kill my brother and the whole family, and that increases their blood pressure, then that would be a valid argument. However, the mere fact of having a condition does not automatically make it extreme hardship. Additionally, if the only reason is economic, that is not enough. Solely economic reasons are not a sufficient basis to get extreme hardship. However, if it's one of other factors, that's important. With the extreme hardship arguments, it's really hard just to pinpoint, because every case is different. Some people may have more educational reasons, some people may have more professional reasons, some people may have health reasons and others don't. Some people may have such rich community ties here and have no family in their country of origin, and every case is really different. I think the important thing to know is that there's just various different factors. Another thing, there's various different factors. No one factor is going to make or break the case, but all of them together, that is what's going to make the difference. For instance, if you have various different hardships with various different factors, although they may not be that strong alone, together it may be enough to prove extreme hardship. In addition, if your extreme hardship isn't that much, but you don't have any other negative factors in your case, that may still be a winnable case. If you have more negative equities, more negative facts in your case, you have prior criminal history, you have other factors that would make your case negative, then you would need to show more extreme hardship to counterbalance those negative factors. When looking at extreme hardship, I think it's important just to think about on the whole, how is this going to impact you? Keeping in mind those different scenarios. One, if my qualifying relative leaves with me to my home country, what are they going to lose? How are they going to suffer? If they have a job here, can they not get it in their home country? What is so hard about that? Thinking about things like that. In the other scenario, if the spouse stays here and you go to your country of origin, what are the difficulties there? If you are the sole breadwinner and they don't work, they just take care of the kids, they take care of a kid that has some sort of medical issue, the argument there would be that they need me for support, that you would have to show the hardship that your spouse would suffer by you not being there. Perhaps she can't pay for the treatment for the private health insurance that the child has. Perhaps there are certain things that are needed. There is a certain vehicle that is needed that allows for the child to get to the medical appointments, that if that vehicle wasn't there, they would no longer be able to get that medical treatment. In addition, another thing I want to mention about the I-601A waiver is that this waiver, if approved, allows you to get that waiver for unlawful presence in the U.S. Once you get that waiver, if there is no other negative reason, if there's no other ground of inadmissibility in your immigration case, you go to your country of origin, you do your interview, you do the consular processing, and you get approved, and you get your visa, and then you come back to the U.S. In order to get an unlawful presence waiver, you got to go to your home country, apply for the waiver there, wait months for it to be processed, and then have your interview. If you found this video helpful, please let me know. If you have any questions, also let me know. Thank you. Have a good day. God bless.